This is right.
Lords, just before the break, I was just dealing with the 2 points that are made, the 2 effective points that are made by my learned friend in respect of Article 19.2.
Yeah.
The first one is that it should have been the appellant that had the right to phone or seek to contact his mother, and the point that I make in response to that is simply this, that there simply wasn't any evidence before the judge on the voir dire that is something that would have made any difference.
You might have tried a different number.
Well, my lord, it's possible, but again, there simply wasn't any evidence before the judge that is what would have happened or what was likely to happen. And what the judge had before him was clear evidence from the officers that they had been given the 2 numbers that the appellant had volunteered, and that it was they who had attempted to make those phone calls, but to no success. In those circumstances, and in the absence of any suggestion by the appellant at that stage that the police were effectively deliberately frustrating his rights, the judge was entitled to conclude that those attempts were genuine ones and that they were made in good faith to contact the appellant's mother. We say that that's an important factual finding reached by the judge, and it's a finding in his voir dire that this wasn't an attempt, a specific attempt by the police to frustrate his rights. The second point is that, well, the police should have gone out and searched the appellant's mother themselves. The short point again here is, well, there was no guarantee that the police would have found her, and there was no evidence before the judge at the voir dire that she was there to be found. And, my lords, I've taken into relevant parts of the transcript which suggest that, save for potential knowledge that the appellant's mother lived in Nassau, the police didn't have any further knowledge as to her address and whether she lived at the same address as the appellant. Now, I accept again that it may have been possible for the police to have made those further inquiries, but what we were dealing with here is a very short time frame. So, appellant detained on the 28th, he's transferred to the police station that morning, and then you have the interview take place the following day. If you are of the view that in some way the police have, by failing to make contact with the appellant's mother, breached the appellant's rights under Article 19.2, then that isn't the end of the matter. What one then has to do is go on to apply the relevant balancing exercise under Mohammed. And that authority is in Volume 1 of the Authorities Bundle, and the relevant part is at 1492. It's worth just having a quick look at it, as that sets out the relevant test for determining the admission of the confession if there is a constitutional breach. Just by way of background, in the Hamid, the board there were concerned with the right to communicate with a legal advisor. There was an innocent failure on the part of the police in those circumstances to fail to inform the appellant that he was entitled to the right to a lawyer, but there was no evidence of deliberate frustration of the appellant's rights in that respect. And the relevant paragraph is at paragraph G at 1492, and it goes across the page at 1493. And the relevant part at 1493 is this: a breach of a defendant's constitutional right to a fair trial must inevitably result in the conviction being quashed. By contrast, the constitutional provision requiring a suspect to be informed of his right to consult a lawyer, although of great importance, is a somewhat lesser right, and potential breaches can vary very greatly in gravity. In such a case, not every breach will result in a confession being excluded. The Lordships make clear that the fact that there's been a breach of a constitutional right is a cogent factor, militating in favour of the exclusion of the confession. In this way, the constitutional character of the infringed right is respected and accorded a high value. Nevertheless, the judge must perform a balancing exercise in the context of all the circumstances of the case. except for one point, their lordships do not speculate on the varying circumstances which may come before the courts. The qualification is that it would generally not be right to admit a confession where the police have deliberately frustrated suspects' constitutional rights. Now, if my friend's right that this is an example of a constitutional breach in the sense that the police either have failed to allow the appellant himself to contact the mother or have failed to take that additional step in terms of directly seeking the appellant's mother, then I say that that is a technical breach of Article 19.2, and breaches of those constitutional rights can vary in gravity and severity, and the question for the board is, well, is that going to be sufficient, or is that properly sufficient to exclude a confession that is effectively voluntarily made based on the judge's findings of voir dire? My submission is it wouldn't be appropriate in these circumstances to exclude. The point is this, that so far as access to the parent is concerned, one has to look at all of the relevant circumstances, and in the absence of the parent, you then have a situation where an appropriate adult is appointed to sit in on the confession interview. So any breach of 19.2 is to some extent ameliorated by the appointment of an appropriate adult, and I'll come on to deal with the relevant attack so far as appropriate adults concerned in due course. But my lords, those are effectively my submissions in respect of 19.2. What I'll do in those circumstances is move on, if I may, to deal with the allegations of mistreatment, which I summarised at the outset, but they come down to excessive and inappropriate questioning over the course of the 28th and 29th, a denial of access to food and drink, and not informing the appellant of his right to a lawyer, and then the appropriate adult point, and I'll take those in turn if I may. So far as questioning and interrogation is concerned, the allegation that seems to be made in the appellant's case and repeated today, as we understand it, is that the appellant was subject to interrogation, effectively, over the course of the 28th, which was the Saturday, and through the evening of the 28th, into the early hours of the 29th, and then again from 9:15 in the morning onwards on the 29th, to the point where his confession is made. That's how it's put in the appellant's case. The starting point, I say, is, well, that's not the case that was put before the judge at the voir dire. What the case was that the appellant was subject to police mistreatment on the evening of the 28th of November, and then into the morning of the 29th. And those are the points that were put to the relevant officers on behalf of the appellant at the voir dire. So the point that's made by my learned friend is effectively an expansion on the allegation of police brutality, which wasn't put before the judge during the voir dire. Well, my friend's taking you to the record, the detention record, and I'd like to just go through that with your lordships as well, as briefly as I can.
Sorry, you're saying that the case as put before the judge was mistreatment on the evening of Saturday the 28th?
On the 28th.
And then into the 29th?
Yes.
Or was it a threat of mistreatment physical mistreatment on the 28th and actual physical mistreatment on the 29th?
Well, it was actual mistreatment on the 28th, evening of the 28th.
Was it?
And actual mistreatment on the morning of the 29th. And one gets that from the appellant's doc statement in the voir dire, and that is at volume 1, page 310. Line 17 onwards. So the first paragraph from line 17 is the 28th, and then from 27 you're then into the early hours, as I read it. So he's saying that it was later, so line 23, later on that evening, they took me out, carried me upstairs to CDU department, where they asked me questions about a murder and armed robbery. I told them I didn't know anything about it. And he goes on to say, this is again on the evening of the 28th. It was Officer Bain and Officer Ferguson went into another room, came back with a stick and plastic bag and a white towel. And he goes on to deal with the allegations of brutality.
But Mr. Atwell, when you say, well, this is a new case, it wasn't so much interrogation then, but allegations of serious brutality, which the judge, of course, entirely rejected. Yes. Wasn't the appellant making a complaint of mistreatment and brutality within the context of a suggestion of an interrogation?
Yes, but only in respect of the evening of the 28th. Now, what's put in the appellant's case is actually, no, it was earlier than that he was being interrogated not just during the evening of the 28th, but at various points, and I think it's 10, 12 in the morning onwards. Or that is the inference that the appellant seeks to draw from that. And we say, well, none of this was before the judge, and that's why it's not dealt with in his ruling on the voir dire. And then you have, later on in the morning, at page 311, line 11 onwards, he got up that morning, 2 officers came into the cell, and he alleges it was ASP Fernanda, Officer Bain, and Officer Ferguson, and about 6 other officers who dished out a beating, effectively. What happened so far as the voir dire was concerned, just going back to the 28th, is that Officer Bain wasn't called to give evidence at the voir dire, but Officer Ferguson was. And it was put to him very, very briefly that he was part of the group that abused the appellant on the evening of the 28th, and he denied it. And then similar points were put to the officers who were involved, who were allegedly involved on the 29th, so Fernanda, Ferguson, Johnson, other officers as well, that they were involved. And again, those officers denied the mistreatment. But there was nothing along the lines of the appellant was held incommunicado, interrogated prior to these events. And that's why it's not dealt with by...
But it seems to be in common ground that he was being interrogated, was it?
No, it's not at all.
Well, you're right that the defendant, in his unsworn statement, refers to being questioned about a murder at page 3110, line 25, for the first time sometime in the evening of Friday the 28th. But had the points which Mr. Fitzgerald makes now about the detention record been made by counsel on the defendant's behalf? Not perhaps in the same way.
Well, certainly, yes. Certainly not in the same way.
No.
And certainly there was no complaint at the voir dire of, if we go back to the detention record, it's quite handy to just tie it up with the chronology. The detention record is at page 12, bar 1. And the first entry of note is 10:12. Prisoner McPhee is taken on inquiries. Chief Inspector Partier, who didn't give evidence at the voir dire, and a team of officers from CDU, doesn't say where he was taken, doesn't say what the purpose is, doesn't say anything really of any illumination as to what was going on at the time. I accept that. But the point is...
So on your case, there's no evidence at all of what happens between 10:12 and 1:30, is that right?
No, because the point's never put to any of the officers that the appellant is being beaten at the time or is being interrogated. So at the voir dire, it's never actually put to any of the officers that this is exactly what was going on. This is effectively a new point.
But is it right, as Mr. Fitzgerald told us, that when they were asked about what was happening to him, they virtually to a man said, "Don't know, but not me"?
On the 29th, that is right. So the officers were challenged to the extent of this, that on the morning...
Did any of them ever say that they'd had any dealings with him on either day?
There are certain officers who say, "I saw him," but they don't say that anything was done. So, but focusing on the 28th...
Well, and are you saying that nobody made the point that there's 3 unexplained hours between 12 minutes past 10 and 1:30?
Those points were put. So
They were?
Yes, it was suggested that the appellant couldn't be accounted for from 9:15 a.m. to the point of his confession. That point was put.
Yeah, that's the following day. I'm talking about...
Yes, on the 29th.
I'm talking about 28th. Three unexplained hours between 10 past 12 or 12 minutes past 10 and 1:30.
Yes.
In other words, the whole morning
Yes.
of Friday the 28th. And are you telling us that nobody pointed that out?
No. No, there wasn't a challenge in that respect.
Okay.
And there was no complaint from the appellant in that respect between 10:12 and 1:30. Now, what you then see, and the handwriting on this record is quite important because the evidence at the voir dire was that the record follows around the officer that takes the appellant out of the cell. Mm-hmm. So the record follows the relevant officer who has either taken the appellant out or who is looking out for the appellant in the cell. At 1:30, he's placed back in the cell by Corporal Forbes. Again, Forbes didn't give evidence at trial. And again, there was no suggestion at this time that the appellant was being mistreated. At 2:18, prisoner taken out of cell, taken on inquiries at CDU. He was in good health. Now, my submission in respect of that is I accept that there's no explanation on the face of the detention record as to what the nature of those inquiries was, but one can infer quite strongly from the transcripts and the evidence that actually what was happening at this point was a bag was being searched, not just the appellant's bag. Just to give you the background, he was arrested in an airport. He had some luggage at the airport. He was arrested with his co-accomplice Raming, who also had a bag. And those bags were taken back to the police station. And the evidence, so far as that's concerned, in terms of the bag search, is set out in Detective Sergeant Johnson's evidence at file 3, pages 674 to 676.
So that's in the trial?
That's in the trial, yes. Well, it might assist if we have a look at that. What you have at 674, line 28, is the officer, D.S. Johnson, describing searching the bag of Raming initially. This is around 2:30 on the 28th. And then over the page at 676, line 11, shortly afterward at the inspector's office, I saw in the presence of Corporal Roll, Shavargo McPhee. I cautioned him. I asked him to point out his bag, which he pointed out, the grey Kelly suitcase, and said that was his own. There was then a check of the suitcase. Various items were found, and then those items were processed. And my learned friend, I think, suggested that this whole process took about half an hour. What he says is that shortly after 3 p.m. he left, but that would effectively amount to half an hour so far as Officer Johnson's concerned, but Johnson's evidence has to be read in conjunction with DC Roll's evidence, which is at 651 and 652, and he effectively corroborates DS Johnson's evidence that a bag search was undertaken at this time. But the point is, again, at the voir dire during the trial, it wasn't alleged that the appellant was being mistreated at that stage. It was only the evening. And then, my lords, if we go back to the detention record, you'll see that McPhee at 3:50, this is page 12, is fed his lunch. So a short point I'd make is, well, if he's being detained incommunicado, if the idea is to interrogate him and break his will, what are they doing feeding him his lunch at 3:50? But in any event, at 4 o'clock, what you then have is a brand new entry from a different corporal, and that's Corporal 1964 Smith. Now, that's an important change. You'll see that the individual that you'll see effectively from this, that the detention record has changed hands. It's gone from the individual that fed him his lunch at 3:50 to Corporal Smith, and Corporal Smith's evidence, I say, is important. His evidence was effectively that he was the station orderly at the time. Just to give you that reference, it's file 1, page 255, lines 11 through to 13. And in his evidence at the voir dire, he described his duties as effectively making checks on prisoners who were held in the cells. He ordered their meals and he updated their detention records. it's relevant to note that he doesn't say, and he isn't asked the question that on the 28th that this entry at 4 o'clock was the appellant being in his cell, but he confirms that on the 29th, a similar entry, the appellant was in his cell. And the reference to that is 1/260, lines 26 to 32. So my submission is, whenever you see on this detention record an entry from Corporal 1964 Smith, the appellant isn't upstairs at CDU, he isn't out being interrogated, he's actually in his cell. And that explains the subsequent entries at 7:50, which is suspect being fed his meal, appearing to be in good health. There's then a further check at 9:56, and then another check at 11:45.
What was the reference where Corporal Smith said that the 11:45 p.m. entry would have been a check in the cell?
My lord, he doesn't say that.
I'm sorry, I misunderstood you.
No, I'm terribly sorry if I've not made myself clear. The position is that, so far as the entries on the 28th are concerned, at no point is it suggested, or at no point is the question put to Corporal Smith that the appellant's in his cell during these entries. But I say that that's the inference to be drawn from his role, which was looking out for prisoners who were in the custody, who were within his custody at the time, and they were in his cell, and also from the evidence that I believe he gave later on, which is that checks were being carried out in respect of Rahming at the same time. So we don't actually have Rahming's detention record, but if you read the transcript carefully, you'll see that Corporal Smith does go on to give evidence that he carried out checks at exactly the same times in respect of Rahming. The inference, again, in my submission being that he's in his cell.
So what happens then in the morning of there's a 1:30
Yes.
a.m. which says, for somebody else's writing,
Well,
says the suspect arrived downstairs from CDU.
absolutely.
So where's the record of his going to the CDU?
There isn't one.
Right.
And that's the difficulty. And the reason, and this is the point that we've made in our case, that the detention record isn't a complete account of the movements of the appellant. I readily accept that. What should have happened, what is clear in my submission is that at some point between 11:45 p.m. on the 28th and 1:30 a.m. he does leave his cell, but that isn't noted on the detention record itself. Now, the reason for that is explained by Corporal Smith in his evidence at 274, and I will take your lordships to that, if I may.
Page?
Page 274 to 275. What you have at line 6 down to the bottom of the page, and then just the first two lines over the page, is a description there by Corporal Smith as to what was going on at the police station at the time. And the important point to recognise is that this is a very small police station, only manned by one person, which had been burdened with a large number of people who had gathered outside the station. The station effectively was on lockdown at the time. And what Corporal Smith goes on to explain is that it simply wasn't possible in these circumstances to ensure that the detention record was completed fully for each of the prisoners that were detained and recorded their movements in and out of the cell as they should have been. That's one reference. You've got further references to the prevailing situation at 262.
That may explain why the record didn't get punctiliously filled in. Follow that as a possibility. But does anybody ever anywhere say what might have been happening? Apart from the mob outside, of course.
My submission is yes in respect of this entry and what was happening at this time. or rather what was most likely to be happening at this time, was that the appellant was being examined by Dr. Swanner.
Doctor.
And that was the blood samples.
By whom?
By Dr. Swanner. And his evidence, my lord, is at file 2, pages 559 through to 560. And he says, I arrived at the station at around midnight or 12:30. This is lines 21 to 23, pages 559 to 560.
Yeah.
And I say, well, that fits in, that evidence fits in with the detention record, albeit I accept that the record itself doesn't reveal what the purpose of him coming back downstairs from CDU is. Well, just to give you one further reference, if I may, Corporal Smith accepts that it wasn't always possible to record the movements of the prisoners within his custody due to the prevailing situation at the station, and that's at 542, lines 10 to 20. So his evidence was that it just wasn't always possible for me to make sure the relevant entries were done. So in those circumstances, what the judge had before him on the 28th from the appellant side was simply an assertion that he was being mistreated on the evening of the 28th, nothing earlier. The point was put to Police Officer Ferguson, who denied that treatment was being dished out. And there was no other assertion on the appellant's behalf at trial that he was otherwise being interrogated earlier during the day on the 28th. And what you then have in terms of the detention record are various entries through the night, 1:30, 2:30, 3:30 and the like, which are simply the appellant being checked. And by that point, he's back in his cell. There's a point made in the appellant's case that, well, why wasn't he being fed or refreshed at that time? And I say, well, he's probably asleep. So there's nothing in that point. But then, if we then go into page 14 and go on to the 29th, you have at 9:15 a.m. Prisoner McPhee taken out of the cell by Sergeant Johnson, and then it's PC 3137 Boatin, who didn't give evidence at trial or during the voir dire, who takes the appellant upstairs to CDU to conduct inquiries. Now, based upon what the appellant was saying in his doc statement, his account was this, that he was being beaten by the police. And his timeline for that, he wasn't particularly specific, but if you go back to page 311 and his doc statement, in fact, he doesn't give a timeline at all, but what he says is that on the 28th, what he says is this, that on the 28th, he was detained for a couple of hours. So the allegation was 28th, it's only a couple of hours, nothing else. And then on the 29th, you have a detailed account as to the alleged beating by the police. Well, I accept that the record doesn't reveal where, it does reveal where he went. He went upstairs to CDU, but I accept that it doesn't reveal the purpose or the real purpose behind that removal from the cell, save for what is said on the face of the record itself, which is to conduct inquiries. Now, it's said that, well, the strong inference is he's being interrogated at this time, and my position on that is simply this, that there just isn't any positive evidence that that was the case, that he was being subjected to improper, lengthy, or inappropriate lines of questioning, or interviews.
Or any?
Or any.
I see.
On your case, what, he was not asked any questions about the case at all throughout this whole of his period, right?
Well, the highest I can put it is there just isn't any evidence as to what was going on that morning. I can't say that he was being interviewed, but then I can't say he wasn't either. But the point is this, that there just wasn't any evidence, save for this assertion on the part of the appellant that he was being beaten at CDU.
There were some questions we referred to earlier where the officers were asked what was happening and they said they didn't know.
Yes. Well, can I give
And
your
I think it
lordship the
suggests
relevant...
that's not very credible.
Well, what happened was this. At Vardir, the point was put to each of the officers, and I'll list them, and I'll give you the references so that your lordships can look at how the point was dealt with. First officer was Fernanda, and his evidence in response to what happened that morning is at 51 to 55, volume 1, lines 21 to 13. You then had Ferguson.
So it was put to him that he was part of the torture, wasn't it?
Yes. You then have Ferguson, that's 277, lines 18 to 22. You then have McSweeney, that's 85 to 86, lines 4 to 22.
Sorry, just to repeat that.
I'm sorry, my lord. McSweeney,
Yeah.
pages 85 to 86, lines 4 to 22.
Yeah.
DC Johnson, beg your pardon, DS Johnson, page 214, lines 2 to 25, and 223, lines 6 to 23. And if your lordships go over those passages, you'll see the points that were put to the respective officers. And effectively, they came down to simple assertions that on that morning, the officers had the appellant in their custody and that he was being beaten, and they say, no, he wasn't. But then they don't then go on to say, well, actually, where was he on the morning? I accept that. But my submission is there simply wasn't any positive evidence that he was being interrogated. Now, it might be, and it might be a reasonable inference to deduce that at some point on the 29th, the appellant indicated that actually he wanted to give a statement and that it was going to be a confession statement, and that would explain the entry at 3:45 and the phone call to the pastor for him to come along and witness the confession statement. But that would be a long way away from saying appellant's been held incommunicado, he's being interrogated, he's not being properly treated, he hasn't got his mum, he hasn't got a lawyer on board or anything along those lines. And there simply just wasn't any evidence that that was the case.
What I find difficult to get around, if we're under Section 20, once the issue of oppression is raised, it's for you to prove that it was safe. And that there were, so the lack of evidence really tells against you, because you're simply not able to show to the judge what actually was going on.
I absolutely accept that the burden's on the prosecution to prove beyond all reasonable doubt that the appellant wasn't being mistreated. And that is what they did in response to the allegations that were raised at the time. And the sole allegation that was raised at the voir dire was this appellant was being mistreated. He was being beaten. And that's why the police called officers Ferguson, McSweeney, Johnson and Fernanda and like to deal with that allegation. Now, if the point had been put, actually, on this morning you were being interrogated, not just beaten, but you were being interrogated, and that interviews were taking place and that questions were being put to you with a view to you confessing to the crime, that's of a completely different nature to what the appellant said in his doc statement and the points that were put to the officers. And it's in those circumstances that the judge didn't deal with these points, because they are effectively new points that are raised for the purposes of this appeal, I say. Had the point been put, the judge in all likelihood would have dealt with it. So my submission so far as the record's concerned and the interrogation is concerned is that there just isn't any scope now for the inference to be made that the appellant was subject to improper questioning, because the evidence wasn't presented along those lines and the evidence wasn't dealt with in that way at the time, because the allegation hadn't been put that way by the appellant.
Where is the record of whatever it was caused them to send for the bishop?
Well, there isn't one.
Is there any possible excuse for there not being?
Well, what happened so far as the bishop's concerned, his evidence was that it was ASP Arnett who phoned him to say, come and witness a statement, come and witness a statement. And that's the only evidence that was led so far as that's concerned. I simply don't know whether there was a record of a request being made, whether it be a form letter or the like. I simply don't know if that is the practice in the Bahamas. But the evidence that was led at trial was this was a phone call from ASP Arnett to the pastor to say, come and witness a statement.
Come and witness a statement?
Yes. Now, I accept that the inference from that is that at some point it's been communicated to the police that the appellant wants to give a statement. But again, the point I make is that's one thing, but it's then a huge leap to say, which is what the appellant says, I was being interrogated, held in communicado and the like. It's not supported by the detention record, and that wasn't the point that was led at the voir dire or at trial. So ultimately, the point comes down to this. I say that so far as the point about interrogation is concerned and the like, this is simply a dressed-up attack on a factual finding reached by a judge based on a set of evidence that was before him, and a case which is now expanded beyond the evidence that was put before the judge at the voir dire. And so far as the judge's findings are concerned, that explains why he was focusing to a large extent on the allegations of police brutality, because that was the point he was concerned with. That was the point that was live before him, not this. Well, can I just deal, just very briefly, one further point so far as the chronology is concerned. What you might have noted at page 17, the question was put, well, what are the nature of these inquiries and the like? Page 17, you'll see that on this is the 30th of...
Page?
This is file 1, page 17, my lady. Page 17.
17?
Yep, 1-7. You'll see that actually the appellant was questioned not just, this is when he's back in Nassau, he wasn't questioned just about this offence, but he was questioned about other offences as well. And so you'll see there's an entry at 9 p.m, and that relates to an attempted murder on the 21st of November in respect of a murder at South Beach Estate, not related to this one. At 10 p.m, he admitted to a murder on the 18th of July 2008 of a man called Raymond Finlay. And then at 10:55, he was questioned regarding a murder on the 23rd of October 2008, an attempted murder. Now, it might be, but again, I can only speculate, I emphasise that that is all it is. It might be that the nature of the inquiries weren't concerned with the offence that we're concerned with here, but related to other offences. And you'll see, so far as the detention record's concerned, that he was subsequently charged with offences on the 1st of December, and that's at page 19 to page 20. And that gives a hint, perhaps, that there was more going on to this than simply the offence we're concerned with. But again, I can only speculate, given the admitted deficiencies in the detention record. I accept that.
Not something that was ever before the judge?
No.
Not raised at all at the trial? No. Right.
Can I deal with the second allegation of mistreatment, which is appellant wasn't fed? You've got the points on the detention records. They show that he was fed on the 28th at 3:50, and he had a further meal at 7:50. And I accept there's no further written record of the appellant being fed after that time until the following day at 6:40 p.m. Now, that anomaly was explained by Corporal Smith in his evidence as being due to the prevailing conditions at the police station, so the mob outside the police station and the like. And the reference to that is file 2, page 521, lines 13 to 32.
So is the mob there on the Sunday? Sorry, I don't mean the Sunday, I mean the Saturday.
Well, the point was made by my friend that the mob was there only on the 28th. Actually, that's not right at all. They were there on the 28th, 29th, and 30th.
Right.
But the adverse conditions, if I put it that way, were dying down gradually, but they were still extant on the 29th and 30th. So I do differ with my learned friend so far as that evidence is concerned.
How much mileage can you make with this point in light of the fact that the appellant told the bishop he was hungry, that the bishop asked the police whether he'd been fed, that the police didn't respond, that the bishop thought he looked hungry, that the bishop fished out a $20 bill and told the police to get him some food, and that the judge found that he may well not have been fed for long periods?
Lord, I'll take it in stages, if I may. So far as the evidence of being fed is concerned, what the judge had before him was the evidence of Sergeant Johnson that he fed the appellant on the 28th, and I'll just give you the relevant parts of the transcript. That's one at page 287. Can I actually take your lordship's?
Well, I mean, we're starting from his being fed at 7:15.
Yes.
On the Saturday. We won't go back prior to that.
No.
Friday.
Friday.
Yes. If we go to 287, I hope this will go some way to dealing with the point. This is Sergeant Johnson's evidence.
This is Sergeant Paul Johnson.
Paul Johnson.
Yeah.
So he was the other station orderly.
He's the station officer, isn't he?
Yeah.
Not the investigator, not the detective who's
No,
investigating.
there are two Johnsons. One's
Two
investigators.
Johnsons, yes.
Yeah.
Line 13 down to line 32, line 28 in particular, or just above that, on the 29th, did you as a station officer order any meals for Shavargo McPhee? Yes, ma'am. My job as a station supervisor is that no matter how many people we have in custody, meals are ordered for them. And then on the 30th, yes, meals were ordered. So there was clear evidence there of the appellant being fed, or meals at least being ordered for him. And then if you then go to 294, he's challenged about this at line 5 onwards. But he's challenged by reference to the record, which I accept doesn't show the appellant as being fed. Line 20, there's no particular reason why he wasn't fed. Isn't it your duty to ascertain why he wasn't fed? Yes, sir. Did you check to see why he wasn't fed? Yes. You checked? I don't recall right now. You didn't check, sir? Yes, I did. I went upstairs and checked. So what, they chased you from upstairs? Right now, and then over the page, when you went up, they chased you down? No, sir, but he wasn't fed, according to the record. Now, that's his evidence that actually he went upstairs. We read that as he was checking to see whether the appellant was being fed on the 29th.
Well, that also is interesting because it suggests that it was not unusual that he might be fed upstairs in the investigation unit rather than downstairs in the cell.
Yes. And that fits in with the detention record. So, for example, you'll see on the 28th at 3:30 he's fed his lunch, but that entry is written by the officer who had taken the appellant out of his cell. So the detention record follows the individual round the police station, and he's not necessarily fed in his cell. Accept.
Well, except that you've asked us to say that the next entry at 4 p.m. we should infer was made when he was in his cell.
Yes, I accept that.
Right.
Well, it's just one further place I can take you is 305 to 308, and that is D.S. Johnson's evidence. Beg your pardon. Sorry, we're still with Paul Johnson at 305 to 308. I just invite your lordships to take note of that. He, again, at 306, he's looking at, he's challenged on why there isn't an entry for breakfast. This is at line 16. Do you know why this is? It's because of the chaos around the station, inside and out. And then over the page, at line 13, 307, you're on duty from 8 to 4, isn't that there? Yes, station manager, yes, one of your duties is to make sure the prisoners are fed. So in conjunction with your responsibility as a station officer having regard to meals, can you explain why there are no entries for lunch? Well, I was busy that day. Lunch was ordered. Lunch and breakfast were ordered for everybody that was in custody. And who ordered lunch, sir? I ordered lunch, Mum. Just one further reference, which I won't take your lordships to. D.C. Johnson, who is the investigating officer, confirmed in his evidence at the voir dire that he made checks that the appellant was fed. And the reference to that is 1/222, and that's lines 5 to 14. And then going to the judge's ruling on the voir dire, the relevant paragraph is paragraph 14 in respect of the appellant being fed, and that's at page 469. It's relied upon by the appellants, effectively. What he says at paragraph 14 is, Mr. Dusil contended the police denied the defendant food for several hours as the detention record of the accused has several gaps and omissions as to him being fed. While I accept there may have been lengthy periods when the accused was not fed, I'm not satisfied that that was part of any deliberate plot to induce him to make the statements which are the subject of the inquiry, which I'm satisfied were given voluntarily and free of oppression. Now, the judge accepts that there may have been a lengthy period, but what he doesn't expressly do or deal with in his ruling here is the evidence of Sergeant Johnson that actually the appellant was fed. The station orderly, not the investigating officer. And my submission is it was...
I'm not sure that his evidence amounts to that. His evidence amounts to that he ordered meals for everyone, and then the passages in 294 don't actually say he was fed.
Well, I accept that Paul Johnson doesn't observe the appellant eating, and he doesn't say, I gave him the plate of food or whatever it was that he got. I accept that. But what there was before the judge on the voir dire was evidence that the appellant was fed, that meals were ordered on his behalf, and that Johnson's evidence is he went upstairs to check that the appellant had been fed. So whether he's seen it or not, in my respectful submission, matters not. It would certainly assist me if he had seen it. But my submission is that there was evidence there in front of the judge to reach a finding, albeit that he didn't expressly make that finding, that the appellant had been fed. But then the judge didn't then go on to say, well, actually, I find that he wasn't fed, simply that there was a possibility. My submission is it's not enough if you look at the evidence of Sergeant Johnson. And my submission is that there was plenty there to find that actually he had been fed, albeit that the detention record doesn't reflect that. Well, just...
If, contrary to all your points, he hadn't been fed for 21 hours prior to the confession, would it be fair to have elicited it from him?
The confession?
Yeah.
my lord, it would need to be demonstrated in my submission that the failure to feed had such an impact on the appellant's ability to give that confession that it rendered it unreliable, or it was otherwise unfair for that confession to be admitted into evidence.
But on whom does the burden of proof lie?
I accept that the burden was on the prosecution to rebut the allegation. So the allegation that he wasn't fed was put in issue, and it was down to the prosecution to show beyond all reasonable doubt that actually he had been fed and the like. I accept that.
He had been fed.
That he had been fed, yes.
But you can't prove that beyond reasonable doubt.
Well, my submission is there were... Well,
That's not consistent with the idea that you could prove it beyond reasonable doubt. It's not consistent with the finding at paragraph 14, is it?
well,
I mean, the question is not, I mean, I thought it's fairly clear you can't prove that beyond reasonable doubt that he had been fed, because the judge clearly didn't find that. But the question is whether that amounts to oppression, and whether that in itself is enough to get him home under Section 20.
my lord, I accept that. I accept that.
And it's clear from the authorities that we referred to that not feeding a prisoner can amount to oppression.
I accept it can, but ultimately each case depends on
And that's
the
to look at
facts.
it in the round, of course.
Yes. Yes, but you might want to be satisfied in those circumstances that that the confession is given voluntarily, and your lordships would need to be satisfied, in my respectful submission, that there's a causal effect on the appellant not being fed and the confession being given. And
So how did the confession come into existence then? Did he suddenly say, I think I'd like to give a making confession? And then was he asked some series of questions and somebody wrote it down? Or did he just get the paper out and write it all out in one go, or what?
well, we do.
Or don't we know?
Well, we don't know the first question, which is how the confession came to be. What we have is a record of interview, which is in the bundle at volume 1, where a series of questions are asked, and this will lead on to the next point regarding legal representation. What happened in terms of the chronology at page 23? You've got a record of interview which sets out a series of questions, which was carried out in front of the bishop, and then you have a handwritten statement which follows that at page 25 onwards. But, my lord, I can't answer the question.
And who wrote that? That's a policeman wrote that out. I mean, I'm not complaining about that, but that's not the defendant's writing, is it, or is it?
Well, it doesn't look like the appellant's handwriting, because at page 30 you have a different form of handwriting which seems to be from the appellant, where he confirms that he's read the statement, he's been told that he can correct it, and that the statement is true, and he's made it of his own free will, and then he initials it.
Looks to be Sergeant 772, doesn't it?
Yes, and that would be D.S. Johnson.
That's a Johnson, isn't it?
Yes. Well, so far as the...
So what was the material available to Mr. Johnson which enabled him to write all that out?
His evidence, I believe, perhaps we can...
Well, the bishop's evidence is that the defendant gave the statement.
Yes.
I wonder what he meant by that.
Nobody asked.
But it won't have been well, it's unlikely to have been in completely connected speech without any intervention from those present.
His evidence at the D.S. Johnson's evidence at the voir dire is at 189 over to 190, where he describes the circumstances surrounding it, but I don't think he says whether he wrote it.
My handwriting.
Yes, I beg your pardon. I'm grateful for the friend.
Which page is that?
192.
Yep.
He doesn't really explain the position, does he? It's the truth of it. So it's a bit of a mystery then how he got, how it came about. It just seems to, it flies in the face of all reality, really. The idea that it obviously didn't immediately come from the defendant. He didn't come out with some great splurge. It was presumably as a result of some questioning. But how then did Mr. Johnson know that he was intending to make a confession? The only reasonable inference one can draw, surely, or that this is what is suggested, is that there must have been a good deal of toing and froing between them before it was possible to put together such a statement.
Well, my lord, not necessarily. If one goes back to the record of interview and looks at the questions that were asked of the appellant and goes at page 24 to question 15, he's asked some pretty general questions about the offence, and then he's asked whether he wishes to give a statement under caution, and he says yes. Do you wish to read and sign your answers? Yes. Now, whether there was anything preceding this, or whether this was the first interview, if you like, one can't tell from the detention record alone, but what one does get from the trial judge's ruling in the voir dire, he is satisfied that this was the first interview. He says that in his judgment. I'll just give you the paragraph number. Page 468, paragraph 12. I'm satisfied all reasonable efforts were made to contact the parent of the accused without any success, and it was not until the next day he was interviewed by the police in the presence of a bishop.
Well, that's not the same thing as saying I'm satisfied that nothing had passed between them before.
I accept that, but
I mean, if you can show us either a finding or cogent evidence that nothing did pass between them, then that's a different matter, and I've missed it. But
no.
at the moment, I confess, I speak only for myself, I'm struggling with the idea that page 23 occurred entirely unheralded.
Well, I can't show you that, and the reason I can't show you that is because it wasn't suggested at the voir dire that the appellant had been subject to interrogation, save for the allegation of being beaten, that he was subject to interviews that preceded the confession interview. And that's what I can't show you.
Well, you can't, but allegations in jurisdictions where there is no contemporaneous record of interviews, allegations of police malpractice leading to confessions are not unknown. Good ones, bad ones, extremely bad ones. They're very common, aren't they?
Oh, just.
And the purpose of the detention record and the various rules are designed, they are all designed, are they not, to ensure so far as possible that a false allegation of that kind cannot properly be made.
Well, I accept that. And what I've sought to do in my submissions is to explain or provide an explanation as to why, on occasion, the detention record doesn't give us as full an explanation as it might and perhaps should have done.
Well, it's not just the detention record, I'm afraid, is it? It's the policemen who none of whom appear to have been able to say what was happening to him, or who dealt with him, or anything.
Well,
except it wasn't me, Gov.
Yes, and
I mean, nobody said that nobody took a statement or discussed the facts with him.
no,
There isn't any evidence from the police that says that.
no, but in fairness, the point wasn't put to the officers.
No.
All that was put to the officers was, on the morning of the 28th, you were beating him.
Yeah.
It wasn't suggested actually you sat down and you were grooming him for a confession interview and you were applying pressure and you purposely didn't have an appropriate adult there or a lawyer on board so that you
What is very difficult to believe is that when they all said, I don't know, in answer to the question whether there had been any questioning, that just seems incredible.
Well, my lords, I've given you the page references.
I understand your point. I can see it's difficult for you, but it's just very difficult.
Yeah. Look, my lord, I've given you the page references for the officers and the questions that were put to them. I would invite the board to read those. My submission is that they weren't invited, given they weren't effectively invited to give an explanation, or it wasn't explicitly put to them the allegation that he was being interrogated. It was only put to them in the form of you were there beating them, and their point of response was no. And so it's not surprising in those circumstances that their evidence didn't go further when the evidence simply wasn't elicited, whether it be from the prosecution or the defence.
Well, I suppose you can say that before the confession falls to be excluded, there has to be a reasonable possibility which hasn't been excluded by the Crown, that it's been obtained in some improper manner.
Absolutely.
So that the mere fact that they'd spoken to him beforehand wouldn't necessarily be enough.
Indeed.
But
well, my submission...
nothing.
Yeah, my submission in that respect is if you're satisfied that actually this confession, pre-record of interview and pre-confession statement, that there was questioning going on, my primary point is no evidence of that whatsoever. But if the board's of the view that actually there was this, that there were interviews, that might be a reason to exclude those interviews in the event the prosecution sought to rely upon the contents of those interviews. And there are cases where that has happened, where the prosecution have done a Q&A with a witness and sought to then adduce it in support of a confession statement. That might be a reason to exclude those interviews, but a causal link still needs to be established that by reason of those interviews, of which I say there's no evidence, that this confession statement is rendered unreliable. And my submission is that's a step too far. Well, I was proposing just to move on to deal with the point regarding the pastor and the appropriate adult in those circumstances.
Yeah.
So far as the appointment of appropriate adults concerned, the relevant provisions, my learned friends taking you to them, they're set out in the judge's rules and the 4 standing orders. What I'd say about that is, so far as the judge's rules are concerned, as if I just, they're in Authorities Bundle 1, tab 6. It's Appendix B, paragraph 4. Page 1249. The relevant provision is, as far as practicable, I'd emphasise as far as practicable, children, whether suspected of crime or not, should only be interviewed in the presence of a parent or guardian, or in their absence some person who's not a police officer and is of the same sex as the child. So far as the judge's rules are concerned, the qualifying requirement for the appointment of the pastor was that he wasn't a police officer, and there's no evidence he was, and that he was the same sex as the child. And again,
if the judge's rules stood alone, would this man, this chap, 17 and a half, be a child?
Be
a young person.
Yes. We accept that the judge's rules would apply. I don't think in the judge's rules that they actually define a child.
The next sentence, of course, in 4 is a child or young person.
Child or young
Rather
person.
indicates that not everybody under 18 is a child.
Well, 18 would have been insignificant in 1964 anyway.
At that stage, you were a child up to the age of 14 and a young person between 14 and up to the age of 17
Hence the
in English law.
Hence the Children and Young Persons Act.
Exactly so.
Right. But that's not your main problem, is it? It's the force rules.
Yes,
Yeah.
and the relevant page is page 1229, and it's paragraph 20. Now, what's said is, if the person in custody is under the age of 18, I accept he was, the station officer must, as soon as practicable, inform an appropriate adult of the grounds for his detention and his whereabouts, and ask the adult to visit the police station to see the detained person. Necessary information must then be given to the detained person in the presence of the appropriate adult, the necessary information being the reason for charge and the like. And what I say about this is that paragraph 20 has to be read in conjunction with paragraph 22. for the purpose of these standing orders, the expression appropriate adult means, in the case of a person under the age of 18, his parent or legal guardian. Now, based on our chronology, what we say is attempts being made over the course of the 28th and 29th to contact the parent. And that's exactly what we're trying to do. So we're trying to contact the appropriate adult, and we're trying to do that as soon as practical, if you accept the evidence of the police officers, which is what the judge did. So I say that there is compliance with paragraph 20 to that extent, and then in circumstances where the police aren't able to contact the parent, they are entitled to either then look for a social worker, and failing that, another responsible adult who's not a police officer or employed by the police.
Could I just, before you continue on this point, in reference to the judge's rules point about child or young person, it is of some interest that in the penal code, on page 1281, a young person is defined as a person who is 14 years of age and under 18 years of age. So it looks as if the Bahamas approach was slightly different to what the English approach was. And that goes back to 1945. This is not the point on which this case is going to be won or lost, but just because of our previous concern with whether the judge's rules provision did apply to a 17-and-a-half-year-old. If that was the understanding of young person in the Bahamas at the time, well then, it would. And you accept, of course, that the force rule applies in any event.
Well, yes. The point that I was making so far as 20 is concerned is that it's not just the pastor we're looking at as an appropriate adult. From the 28th, we're looking to have the parent. And so the attempts are being made. And it's reasonable for those attempts to be made in the first instance to contact the parent. You've got your hierarchy at paragraph 22A, points 1 through to 3. And the first name on the list is the parental legal guardian. So if the police are, as they're entitled to do, taking steps to try and contact the parent, they can't therefore be criticised, in my submission. And they
Are you saying that the bishop was an appropriate adult, or that in the circumstances of reasonable attempts to contact the mother, there didn't need to be an appropriate adult?
No, my submission is he was an appropriate adult.
He was?
He was an appropriate adult because he qualifies under the judge's rules as an individual that is an appropriate adult because he was of the same sex as the young person or child, and that he wasn't connected with the police or employed by the police. And he also falls within the definition of an appropriate adult under paragraph 22A, subparagraph 3. And this is a different definition to an appropriate adult than that which appears in the judge's rules. He was a responsible adult who wasn't a police officer or employed by the police. Your lordships will note that there's no requirement that the appropriate adult be of the same sex here. And that is the wording that is taken from Pace Code C.
Well, then the next question is, what is the function of the appropriate adult in circumstances like this?
Yes.
Collection of a confession from a 17-year-old.
Yes. There are a number of answers to that. The first place to take your lordship is to Pace Code C, paragraph 11.17. That's at page 1357. So if an appropriate adult is present in an interview, they'll be informed that they're not expected to act simply as an observer and that the purpose of their presence is to advise the person being interviewed, observe whether the interview is being conducted properly and fairly, and facilitate communication with the person being interviewed. Now, my submission so far as the so far as the pastor is concerned is he clearly satisfies the second condition of the second bullet point, which is that he was there to observe whether the interview is being conducted properly and fairly. That was his evidence. And he clearly satisfies the next condition, which is that he was there to facilitate communication with the person being interviewed. So far as advise the person being interviewed is concerned, you don't have any definition in PACE Code C as to what that involves. But what you do have in some of the cases that are relied upon by my learned friend is, to a certain extent, a discussion of these points. And the starting point is DPP against Blake, and the relevant page is the Full Authorities Bundle 1, page 1455. This was the case where the appropriate adult was the estranged father of the juvenile. And at 1455, paragraphs G and H, you've got the section at G that I've just read out to the board, and then just below H, it's apparent from that note that the appropriate adult, in the terms of the code, has an important role to play in any interview which he attends. He or she is there to advise and to observe for fairness, and if necessary, to help if any problem of communication arises between the questioner and the person being questioned. Well, that doesn't really get to what we're after here. The starting point, in my respectful submission, is it's got to be recognised that the appropriate adult isn't a legal representative, so he's not there to dish out legal advice. The next relevant case, if I can take your lordships to it, is R against Hussein. That's again in the same bundle, Authorities Bundle 1, 1472. It's a relevant part. And there's, at paragraph 36, there's some quotes from the Royal Commission report. Juveniles may not as readily understand the significance of questions or what they themselves say and are likely to be more suggestible than adults. They may need the support of an adult presence or of someone to befriend, advise and assist them to make their decisions. This presence is, however, no substitute for having access to legal advice, and the right to that applies equally to a juvenile. Whether or not the juvenile is in care and whether or not the social worker is standing technically in loco parentis, the social worker should have the same function as the juvenile's parent, providing support and advice, and he should have an opportunity to speak with the juvenile in private. Generally, the social worker should be present to ensure that the person being interviewed understands the questions that are being put to him. He should not attempt to act as his legal advisor. And then, my lords, if I take you to Roll, which is an authority that my learned friend took you to, which is in the second authorities bundle at page 1613. My learned friend took you to this, so you have the reference to Blake. You have the reference to Blake at paragraph 24, which I've just taken you to, and then over the page. The Court of Appeal of the Bahamas here recognise that PACE, Code C, doesn't apply in that country, but what they do is they urge, so far as they're able to do so, the police officers to give effect to the spirit and intent of the judge's rules and ask them to explain to the appropriate adult exactly what his role is. And what's found there is that the individual that attended the station just simply wasn't aware of why he was there. He was the appellant's brother and the like, and simply didn't know what his job was, effectively. So perhaps that one doesn't give your lordships much assistance, but there is one authority which I have, which isn't in the authorities bundle. Perhaps I can hand it up. Well, this is Jefferson.
Thanks.
Well, the point that arose in Jefferson is at pages 27 and 28. So this is in respect of the appellant Keogh. He was 15 at the time he was interviewed by the police. Prosecution relied on the interviews. The father accompanied him to the interviews. This is halfway down the page. What he did was he intervened robustly from time to time, sometimes joining in the questioning of his son and challenging his exploratory account of certain incidents. There was one interview which lasted 54 minutes. Father intervened 11 times. On some occasions, to clarify the answers of the juvenile. Other occasions, he commented on them. And in one occasion, he contradicted them. There was a second interview which was of less importance. The Court of Appeal referred themselves to relevant paragraphs of pace. And then at the bottom of the following page, at page 28, the Court of Appeal reached their view that effectively Keogh's father was not estranged from him, unlike in the case of Blake, or unwanted at the interview by him, as in the case of Blake, or unable to form the role required of him. The fact that he may have been a somewhat critical observer and participant at the first interview doesn't mean that he did not fulfil any of the three functions specified in that note of advising his son where necessary, observing that the interview was fairly conducted, and if and where necessary, making sure that the police officers and his son understood each other. He had no further duty, as counsel for Keogh appeared to suggest, of protecting his son from fair and proper questioning by the officers, for example, by advising him of his right to remain silent, or by refraining from intervening to encourage him to be truthful. Encouragement by an appropriate adult of the juvenile who is being fairly interviewed to tell the truth should not normally be stigmatised as a failure of the adult to fulfil the first of his duties under C13C, namely to advise him, nor should it have the consequence of turning him from an appropriate adult to an inappropriate adult for the purposes of those provisions. So what's ultimately the nub of my learned friend's complaint is, well, appropriate adult here, the pastor, all he did was he went to the interview, he sat there, he did nothing, didn't advise him. And what's implicit in that argument is actually the appropriate adult should have gone further. He should have said, actually, do you know what? You can actually keep quiet here, or you can appoint a solicitor. Now, so far as the solicitor point is concerned, the evidence of D.S. Johnson was he did inform the appellant of his right to speak to a lawyer at the outset of the interview. And so far as right to silence is concerned, the confession interview and the record of interview was done after a caution had been given. So neither of those 2 points we say arises. What you then have is the pastor come in. All of this has to be seen against the background of what the appellant said in his doc statements about the interview himself. And his account differed, in my submission, quite considerably between his evidence in the voir dire and his evidence at trial. Can I just take the lordships as quickly as I can to what his accounts were and the role of the pastor? That's in volume 1. What he said in the voir dire, during the voir dire, is at page 313, line 4 onwards. This is after he alleges he's been beaten. He says that Inspector Lloyd came in the room and said, "We brought a pastor here for you to sign these papers." Fernando said, "If you don't sign the papers, we're going to deal with you again." After that, I went to the room, and then they bring the pastor in the room. Me and Sergeant Johnson was in the room. When the pastor came in the room, he told the pastor, "This is the statement I give him. This is the interview I give him." In other words, the statement's pre-prepared. After that, the pastor looks over it, reads it in his mind, and then after that, Sergeant Johnson tells the pastor to sign it. And after he tells the pastor to sign, the pastor signs it. And then he told me to sign it, and after that, I refused to sign it about 3 times. The pastor asked me why I didn't want to sign it, and I tell him because my lawyer and my mummy ain't here. So the pastor said he don't have to sign because the mummy and his lawyer wasn't there. So the appellant's account at the voir dire is actually, I did tell the pastor that I didn't want to sign it. And his account is effectively, I'm able to tell the pastor of this wrongdoing.
But
So
the pastor doesn't say that, and the
Pastor
pastor's
doesn't say
evidence was very much believed.
yes, absolutely. But what I'm pointing out is that the case that's now being advanced by the appellant is completely different to the case that was advanced by the appellant at the voir dire.
Mr. Atwell, when the pastor gives evidence to the jury, I think it is, yes, to the jury, I went there to witness the thing,
Yes.
the signing, not to ask questions. Do you think he had a reasonably accurate perception of his role as an appropriate adult?
Well, no. What he was there to do was to inquire as to effectively the well-being of the appellant. So he had a duty to advise. It's the points that I've taken your lordships to: duty to advise, duty to observe the interview was being conducted fairly, and a duty to facilitate communication. And so far as he says, well, my duty is limited to observing the interview, I accept that that's wrong. But what one can take from the pastor's evidence is that his involvement went further than that. So his evidence was, well, actually, the juvenile looked pretty tired to me, and he looked pretty hungry to me, and he intervened. So the pastor was aware of what his duty was, and the pastor's evidence ultimately was this wasn't a forced confession at all. So if that's the accepted evidence, then there was nothing further for the pastor to do in circumstances where DC Johnson has already advised the juvenile of his right to speak to a lawyer, and in circumstances where the appellant's been cautioned that he has the right to remain silent at the interview as well. So we say, insofar as there is a deficiency on the part of the pastor, and in terms of his understanding, it doesn't have any effect on the voluntariness of the confession statement or its reliability or its fairness in those circumstances.
As long as something improper hasn't gone on before.
I accept that.
And do you agree that the effect of the force rules is that if there had been an interview before the one which we've got recorded at page 23, the appropriate adult should have been present?
Yes, an appropriate adult has to be present at an interview.
Yeah.
But I don't want to...
So that goes back to the question we got on before.
Absolutely, I don't want to repeat my submissions on that, but the basic point is no evidence of it. So I say no deficiency so far as...
Can I just ask you one other question, going back to the document we were looking at before? Is somebody under 18 a juvenile?
The full standing orders, my lord.
Well, I only ask you that, but yes. I only ask you that because if you look at paragraph 70,
Go on.
Yes.
it provides interviews with juveniles or persons who are mentally ill and so on will only take place in the presence of an appropriate adult,
Yes.
as defined in paragraph 20, which is the one we were looking at before. But an inspector may allow an urgent interview of such persons with no appropriate adult present if the condition at set paragraph 64A applies. And paragraph 64A is a case where...
Yes.
Well, that's finding the gun, that sort of thing.
Yeah, that sort of thing. So on one view of these rules, they forbid, save in those exceptional circumstances, an interview at all without...
Yes.
So you accept that, do you? Yeah, thank you.
Well, even if you find that the judge's rules or the full standing orders have been breached in the sense of the pastor either not understanding his duties as an appropriate adult or not complying with them, whether they be common law or statutory, one then has to go on to apply... one then has to ask themselves, well, does that render the confession inadmissible for breach of those judges' rules or full standing orders? And the relevant test is set out in Pert against the Queen, Authorities Bundle 1, tab 19. My learned friend took you to it, but the basic points are that the judges' rules themselves are not rules of law, but they're of importance in embodying the standards of fairness, They don't limit the judicial power to admit or exclude the statement, whether a breach takes place or not. And the criterion for admission of the statement's fairness and the voluntary nature of the statement is the major factor in determining what's fair. But ultimately, one considers all of the relevant circumstances. My submission, effectively, is that so far as the pastor is concerned, he did what was required of him. There's a complaint that he doesn't get to speak to the appellant privately, but again, there's no suggestion either from the appellant's doc statement or in any of the evidence that that right was deliberately frustrated, that he asked to be with the pastor privately. I accept, conversely, also what might be the suspicion and what might be said against me as well. The pastor didn't say, let's have a chat privately, but query whether that was of any causal relevance so far as the confession was concerned. I accept he doesn't advise the appellant to say nothing, and I accept he doesn't do that, but my submission is that's not his role as an appropriate adult. That would effectively amount to legal advice. And so he can't be criticised for that.
Am I right in thinking that in principle, as a matter of good practice is concerned, the good practice would be to allow the appropriate adult to see the child, if you like, or the interviewee, before the interview starts? Seek such advice as he thinks appropriate.
Well, no doubt that would be good practice. I don't believe the full standing orders go that far, and nor do the judges' rules. It might be good practice, but again, that wouldn't be a reason unless it could be demonstrated.
And I see they do go quite a long way, because paragraph 60 provides for a record of interview of a pace kind.
Yes, and we say, so far as the relevant interview is concerned, there was a record of it, and it's the record of interview that you have so far as it relates to the confession statement. And so we say, well, those points in terms of keeping the record, keeping a record.
So this all depends. We're back to the point of whether that was
whether that was the only interview,
the beginning of the end of the story, or halfway through the story,
absolutely,
or the whole story.
Well, those are effectively my points so far as appropriate adult is concerned. The points in respect of the application of the Evidence Act simply flow from the board's view as to whether there's something in these complaints or not, whether there is evidence of oppression. My submission so far as that's concerned is, well, that the judge considered the complaints that were put before him at the voir dire, and he dealt with them in a manner in which he was entitled to do. He dealt with the complaint regarding police brutality. He dealt with the complaint regarding the appellant not being fed. He dealt with the complaint so far as access to a lawyer was concerned, and he dealt with the complaint regarding communication with the mother. And those were the essential complaints that were before him at the voir dire. And there's no clear error of law in his judgment so far as that's concerned. So my submission is there's simply not sufficient evidence here, or there wasn't sufficient evidence in front of the judge to show oppression, and he was entitled to find that. Again, there wasn't sufficient evidence in front of him so far as reliability is concerned for him to find that the statement itself was rendered unreliable by anything said or done before it. And similarly, it didn't fall to be excluded on fairness grounds.
You have the two other points to deal with briefly.
Yes.
A lot of time.
Yes, very briefly. Mushtaq is the point relating to the judge's direction. It's useful just to have a very quick look at what his direction was. It's at page 882, lines 26 to 32. I beg your pardon, it starts at line 14 onwards. And the point I make is this, that what he says is, McPhee says that although he signed or initialed the two documents, his initial was obtained by oppression and torture, which is right, that was the complaint that was before him and before the jury. He didn't give the contents of those two documents to the police. He said that after he was tortured and after having suffered oppression at the hands of the police, including being denied food for over 24 hours. So food's mentioned to the jury, denied his constitutional right to communicate with his parents or an adult. Again, that's identified. and not informed of his right to consult with an attorney, again that's mentioned, he was forced to initial the documents. And then the relevant Mushtaq directions applied. If you're satisfied beyond reasonable doubt that the confession was not obtained in this case and that it was true, you may take it into account when considering your verdict. If you think the confession statement's records were into you were or might have been obtained as alleged by the defence, you must disregard it completely. Well, I say that covers it. If the jury couldn't have been left in any doubts that if they were satisfied that he hadn't been afforded his constitutional right to communicate with his parents or an adult, or not informed of his right to consult with an attorney, or any of the other complaints are made out, then they couldn't rely on the statement. So my submission is the direction, so far as it stands, is adequate to protect any prejudice to the appellant in those circumstances. Well, that effectively leaves the new point raised by my learned friend. Well, it's a point that we became aware of yesterday. We received the authorities at around 5:30. But there is prejudice here in the lateness, and I'll explain it this way. If one goes to page 817 of the transcript, what happened is it was the appellant's co-accomplice's counsel who raised the point initially, Mr. Sherland, who canvassed at that stage whether accident, in other words, accident or intention was an issue here, and whether there ought to be a specific direction in that respect. It was canvassed between the judge and Mr. Sherland over the course of 817 lines 17 through to 18 on page 818, and then later on at 821, it was canvassed with the prosecutor, Mr. Colley. Now, his initial impression was actually, yes, this might be something that is worth running, or worth considering at least. Page 821, line 18, the issue is, my lord, whether or not that activity brings into focus lack of intent. And if it is lack of intent on his part, lack of intent to do what, to kill, it is initially, at least, dealt with by the prosecutor on the basis that this is something that should be considered. But what he says at line 9 on page 822 is, my lord, I have to look at that issue again. And what then happens is the court says, well, we should all look at it, and we need to, and please send me an email. So if it was an accident, we'd accept that if it's an accident, that would not lead to manslaughter. Anyway, I'll need to look at it, I'm not sure. The discussion there is about accident, as opposed to manslaughter. But in any event, you see, because to leave accident, it will almost have to be an admission of guilt for armed robbery. When you're challenging all these things, because you don't get to the murder unless you go for the armed robbery. I'm not entirely sure I understand that, but the point is this, that it's left with the judge inviting the parties effectively to make submissions on the point as to whether there ought to be a specific direction relating to this issue. And what we then don't have is either a copy of those emails, we don't know whether they were sent, we don't know whether the judge gave a ruling, and we don't know what his reasons were if he did. And so what we would have liked to have done, had the point been raised earlier, is to investigate the position and to have seen whether the judge did give a ruling on it and whether reasons were provided, or whether there was any document as to the reasoning behind why the judge didn't then proceed to go on and give the Coots direction. And so what we say is, by reason of the lateness of this point, there is a risk, or a real risk, that the board in these circumstances doesn't have all of the relevant materials before it. But aside from that point, I can deal with the point as it's presently put. Because of this, if one goes to the confession statement, which is at page 32 of bundle 1, what the appellant said was this, just after a third of the way down that page. when I turn my back, I see the guy who's by the cash register running to the back of the store. I go on after him, and I catch him in the office by the door, shaking on it, trying to open it with the key. And what's implicit in that is the victim's trying to get away. Then I point the gun at him and tell him not to move, and I went up close to him, and me and him started to hassle. And just pausing there, he doesn't say what he means by hassle, but clearly perhaps we can take it to be some form of tussle. But what he goes on to say is he was trying to hold my right hand. He doesn't say that the right hand came in contact with his right hand, with the gun in it. So I start to squeeze the trigger and some shots gone off. And then it's relevant then to note what happens afterwards. I call for Vardo, the co-accomplice, to come. He came in the back. I walk out after the guy let me go. I walk out to the front and I hear one shot go off. What I say about that passage, in other words, is this, that it doesn't reveal an obvious alternative verdict of manslaughter based on those facts, and that's the test. That's Bingham in Coots at paragraph 23. It has to be an obvious alternative verdict. And what it doesn't reveal is that the trigger was caused, or the pulling of the trigger was caused by the hassle. It doesn't reveal that the appellant suggested that this was a form of accident. It doesn't reveal that he intended in some way, or he didn't intend in some way, to pull the trigger. And it certainly doesn't reveal that the deceased grabbed the right hand, merely that he attempted to grab it. Now, my submission in that respect has to be read in line with the post-mortem report, which you have in the bundle at the relevant parts are at page 35 and 36. My lords, you've got a list of the injuries at page 35, points 1 through to 6 onto the following page. They're irregular-shaped, lacerated, grazed gun wounds in the right upper outer chest. That's at 1. There's a lacerated, irregular-shaped gunshot entry wound into the left lower outer abdomen. There's then another wound on the mid-back right chest, but you get a clearer idea of what happened at page 36 and the possible path of projectiles. Entry in the left lower abdomen, abdominal cavity, travelled upwards towards the right chest, injuring abdominal aorta, intestines, diaphragm and right lung to exit in the mid-back of the right chest. So entry from lower abdomen, and then it's a shot up. And the evidence at trial was this appellant was a short man. The deceased was 70 inches, so around 5'10" or so. I say, well, if that was the evidence that was before the jury, then that effectively amounts to clear evidence of intent, we say, to kill. And if that matter were left to the jury, they would inevitably have found that the appellant would have had the requisite intention for the purposes of a murder charge. Well, there are two other cases that are referred to in my learned friend's supplemental note, one which is Ferguson and one which is Dean. He hasn't handed either of those up, but I'd invite those to be put before the board. So far as put before the board in due course, but so far as they're concerned, Ferguson was a case where there were 3 shots to the chest and there's clear evidence of intent, and in Dean there were 2 shots to the chest at close quarters between the assailant and the deceased. And again, the courts in those cases found evidence of clear intent, and that a manslaughter verdict wouldn't really have taken matters much further.
Well, hang on, what was the question in those cases? Whether the proximity of the shots was sufficient for a jury to conclude that there was an intent?
Well, I don't think those weren't the principal issues.
Right.
But what was said was, so far as Ferguson's concerned, there was discussion the Penal Code, section 12.3.
Yeah.
And they found that there were effectively challenges to the judge's directions so far as 12.3 was concerned, but they found ultimately that the misdirections weren't of any relevance because ultimately intent was always going to be made out based on the facts of those cases. And so that's why my short submission here is the answer to this is there's simply no evidence of intent here, and even if it's arguable, it wasn't an obvious alternative verdict to be left before the jury. And so Coutts doesn't take the matter any further in my submission. But I say in any event, this is a new point. On the default, if there were legs in it, it perhaps might have been raised sooner, but in any event, the board doesn't have the benefit of the Court of Appeal's view on the issue, and that is something that plainly would have assisted the board. And it's a point that's taken at the last possible moment. And my submission is bearing in mind the risk of prejudice here, bearing in mind the fact that the board may not have all of the relevant materials, I don't put it any higher than that, then it's effectively a point that ought not to be considered. But I've made my submission in respect of the post-mortem, I've made my submission in respect of the statement itself, and that submission effectively is no clear evidence of intent. Unless I can assist any further.
It appears not. You've been very helpful. Thank you very much indeed. Thank you.
My lady, can I very briefly invite you to go to our supplementary case in reply, because that really summarises the points I make in response to my learned friend. If I can go to the supplementary case number 1, which starts with new issues. Just looking at page 2 of that, the reasonable opportunity to communicate with his mother, we simply say that my learned friend has not answered the point, but as a matter of statutory construction of the Constitution, the right is the right personally to communicate, to be afforded an opportunity to communicate personally. It's the right of the suspect to communicate directly and to be afforded a reasonable opportunity to communicate, not if it's reasonable to be afforded an opportunity to communicate, but to be afforded a reasonable opportunity to communicate. And we say he was not afforded any opportunity to communicate at all. He wasn't even given a chance to phone her himself. And the reasonableness issue does not qualify the attempts to afford, it qualifies the opportunity. So obviously you can't say I need 3 hours necessarily of communication, or I want to communicate in a private sort of lounge. You may have to take your reasonable opportunity, may have to adapt to the circumstances that are available, but you are to be afforded an opportunity to communicate. And he was afforded no opportunity whatsoever to communicate. Firstly, because he wasn't allowed even to phone. And secondly, and this is our alternative point, that they simply didn't take what we say would be obvious steps to ensure that his mother was informed and notified by going around. Now, my learned friend says, well, they didn't know the address. Well, there's no evidence that they inquired. But in any event, they did, as my Lord Carnwath pointed out, I think, it was that they had his address. And the address, in fact, was the same, and it was a reasonable assumption, the age 17, coming from Nassau, he lived at his mother's address. So those are the points we make in response on that. On the interviews, my learned friend suggests that it was never his case that he was subjected to questioning before the interview that led to the confession. It was suggested that he was subjected to questioning, And if one looks at one of the passages my learned friend referred you to, pages 51, one can see that there, the officer Fernandez is being questioned. He's being questioned about the morning of the 29th. We can see that from page 49. And it's put to him at page 51, line 21 onwards. I'm going to suggest to you, sir, that you asked this young man questions about a murder. Told you nothing. No, sir. You never asked him anything about murder. No, sir. You mean McPhee? Yes, McPhee. And I'm suggesting you, sir, so he is saying you asked him questions about that murder and then went on to that. So there's no doubt that he is suggesting that this was in the context of an unrecorded interview on the morning of the 29th. And so, moreover, the statement of the defendant himself said he was questioned on the evening. Now, evening, given it's November and gets dark early, can be any time from 4 p.m. onwards in Bahamas. And so that allows for him saying, I was questioned any time after 4 p.m., going up to far late into the night. And so that it was put, both by him and in questions, that he was questioned at those unrecorded interviews, at least one extending from what we would call the afternoon into the night, and on the 28th, and in the morning of the 29th. So we do respectfully submit the allegation of unrecorded interviews having taken place was made. It's true that he was alleging that he was beaten up during the course of the second of those interviews. It was the second of those interviews that he was alleging it, and the judge didn't believe him on that. But that doesn't, we respectfully submit, absolve the judge of the duty to make a finding as to whether he was interviewed. As my Lord Carnwath put to my learned friend, if you raise the issue of oppression, particularly in relation to a 17-year-old who's saying he never saw a lawyer and never saw his mother, they actually have got to give a blow-by-blow account of what happened. There is a burden on them to say what was happened and why he was detained and what happened during the course of his detention. It's not good enough to say you haven't proven, because it's not recorded, that he was questioned. We say, firstly, they didn't give any explanation of what was going on, apart from the blood test and the bag, which takes a total of 45 minutes, during that period from 9:10 a.m. On the Friday to 4 p.m. on the Saturday. And therefore, you couldn't say, beyond reasonable doubt, that you're satisfied there was no oppression. Or no causative oppression. Then we make the points, it's really at page 5, Inspector Lloyd said inquiries could be interviews, and that's the reasonable inference. We make the point that Bishop Henfield was called because they wanted you to witness a statement which indicates there must have been some inquiries, some interviews before that, as indeed the appellant expressly alleged, and the removal from the cells on the 28th is simply not explained by a search of the property which took about half an hour from 2:30 on the 28th and a quarter of an hour period, volume 2, page 554, when the doctor says that he took a blood sample on the night of the 28th/29th. So we say that's just simply doesn't explain. It leaves very large periods of time unaccounted for with an inevitable, reasonable assumption that he is being questioned during that period. And in any event, a massive question mark about what on earth is going on with him. So that's our submission. We say there must then at least, in this 3.8, be a likelihood or a very reasonable possibility the appellant was interviewed without a lawyer or parent, without any appropriate adult, without any record. And that of itself is enough to justify exclusion, we would submit, in the discretionary exercise, and to give rise to a suspicion of oppression. But then you have the bishop's presence. We say, firstly, he's not an appropriate adult. Just very shortly, we say they didn't go through the exercise, which is laid down at page 1230 in the rules. The exercise of saying, is there a parent available? No. Is there a social worker available? No. Is there some other appropriate adult? Yes. That exercise simply didn't take place. And it's not within the what they call in Roller the spirit or the letter, the spirit of the rules, to just get the bishop to come round and witness the confession. Moreover, the appropriate adult wasn't brought in at the earliest stage. It took it took really 30 hours before anybody was brought in. And we make the points 4.2 as to whether he was appropriate. There was no prior relationship with the appellant at 4.21. Secondly, as to his role, we do submit that the role should be one of an advisory and protective nature. And the two obvious things the bishop didn't do was to say, have you got a lawyer? You really ought to consult a lawyer before you take this big step. And secondly, given that he'd discovered that he hadn't eaten and had asked the officers and they said that the officer didn't answer, to say, well, I'm not prepared to carry on with this until this young man's been given something to eat. So he didn't operate a protective or safeguarding role, and he himself described, as my lords have put to my learned friend, I didn't went there for his complaint, I went to sit and listen to him, and that's we've set out from page 171. So he didn't see his role as that of safeguarding and protecting, but of listening. My learned friend has referred to Blake, and volume 2, page 1455, and he's referred to Hussein, volume 2, pages 1472 to 1473. We say that those cases make it clear that the role has got to be somewhat more active than just observing, and that you are there in a protective role. And the case of Roller makes that clear to tab 29, page 1614. And so we've set out the things that we say the bishop should have done, and he should have also been afforded an opportunity to speak to the appellant in private. And essentially, we've set out that he therefore was not appropriate and didn't operate the role of an appropriate adult, the protective role of an appropriate adult. On the food and water, really, my lords have already put it to my learned friend, really, at the end of the day, what we have now is the judge said, I think he effectively may well have been deprived of food and water for a long period of time. The evidence that he was given food and water was firstly, it's set out at 5.1, Roman 1, Lorenzo Johnson saying, he couldn't say that he'd seen him eating, but he said he probably inquired whether he'd been given breakfast, and we've given you the reference. That's not good enough in our submission to rebut the clear evidence that he hadn't been fed. And then Sergeant Paul Johnson, we've set out his answers, ending up, he wasn't fed according to the record. And he says, I don't recall right now as to whether he checked.
And then he says he did check. Well, we've got it all here. We've looked at it all. Yes.
By the way, we just say it's far too inconclusive if you take the evidence as a whole to be satisfied. And in any event, the judge wasn't satisfied, and that's perhaps the major point. And you have the points about what Bishop Henfield said, set out at page 10 at the top. And we say, given the judge's finding, given the testimony of Bishop Henfield, there's no way the judge could be satisfied beyond reasonable doubt that he had not been deprived of food and drink. In fact, the reasonable assumption would be that he had been so deprived. And Praga recognises that deprivation of food and drink can constitute oppression, all the more in the case of a 17-year-old who doesn't have a parent, doesn't have a lawyer, and where the bishop doesn't say, look, you really ought not to be conducting an interview until this person has had something to eat. And then, so that's the point. On the legal representation, we simply make this point, that the prosecution, and this is at 6.2, rely on the fact that D.S. Lorenzo Johnson said that he informed the appellant of his right to seek legal representation. There's no record that he was informed of that. Bishop Henfield didn't recall D.S. Johnson asking the appellant in his presence if he wanted. He said, I just can't remember him doing that. And the judge made a finding that there may have been an omission to advise him of this right. So there's no record. Bishop Henfield, the independent person, couldn't recall it. The judge doesn't even make a finding that it was done. So we submit that D.S. Lorenzo Johnson's evidence is far from conclusive. Now, if he wasn't advised at the start of the interview that led to the confession and at the start of the confession that he was entitled to a lawyer, then all they can rely on is the fact that he ticked a box saying, I've been informed of the right to a lawyer 30 hours before. We say that's manifestly inadequate. So on all those grounds, we say there was ample grounds, and indeed the only reasonable conclusion would be to exclude in discretion, and that the prosecution certainly did not discharge their burden under either A or B of showing there was no oppression and no things done or omitted which led to unreliability. And we've dealt with the Mushtaq direction. The only further points on the misdirections, my learned friend says that the prosecution had been prejudiced because there might be a ruling. That's, we respectfully submit, fanciful. This is a complete transcript where there are rulings there in the transcript.
But Mr. Fitzgerald, it is a puzzle. There was this discussion.
Yes.
And then I think you said, and then when he does his summing up, the judge says, well, this is murder. There's something missing. And Mr. Atwell, don't you accept that he may have had a point in saying, well, they haven't had time to fill in what was missing?
Well, my lords, can I just take that? Let's suppose there was an email. Because there's no ruling. We know there's no ruling because all the rulings are contained in this. I mean, the ruling on admissibility. So, let's supposing there were emails which convinced the judge. Don't do this. So what? I'm not trying to be rude. I'm just saying, just so what? That's what is shown by Coates and by Stark. It doesn't matter what anybody says. If on the evidence, that's to say the confession, the issue of lack of intent to kill, and it's got to be an express intent to kill, arises, it should be left to the jury. And it doesn't matter what the prosecutor says, what the defendant says, what the co-accused says. The issue in the end would still be, on that confession statement, does the issue arise? And even if his own counsel, as in Coates, said, please don't leave it because I want to go for bust, that's not a reason not to leave it.
Do you agree with Mr. Atwell that the test which Lord Bingham proposed in Coates was that before a requirement to leave an alternative verdict arises, it must be obviously raised by the evidence, that is, an alternative verdict which would suggest itself to the mind of any ordinarily knowledgeable and alert criminal judge?
Yes, my lord, yes, I accept that. And we would say it does obvious.
Yes, I appreciate you'd say that.
Sorry. Should may not be very helpful. But can I try and be a little bit more subtle than that? What we say is the issue of lack of an intent to kill does obviously arise. And if the issue of lack of an intent to kill obviously arises, then that gives rise to, well, if there's a lack of an intent to kill, is there an alternative verdict? The alternative verdict is manslaughter, that ought to be left. You couldn't, in our respectful submission, say that on those two sentences and the post-mortem evidence, no issue arises as to lack of intent to kill. At least one couldn't, I put it another way, you couldn't say that the only inference, the inevitable inference that any judge or jury would have to bring is he had an intention to kill. And therefore, if that issue arises on those two sentences, which are the only evidence of what went on, then manslaughter, because it's the only alternative, there is a lack of intent to kill, arises. So that's why we respectfully submit. And I know you may say, well, it didn't seem to occur to us, but, you know, hominods and all that. So, I mean, we sometimes you have your eye on the appellate stage on the wrong or on a particular point. Don't look at others. But my lady, those are our respectful submissions. I mean, if the board, I'd rather doubt after 8 years that emails flying around then wouldn't necessarily be available. But I think I have to take my stand that even if there were, they wouldn't make any difference, because in the end, it cannot depend on the submissions put to the judge. At this level, it has to be the test that my Lord has posed to me is an obvious alternative.
Well, thank you very much. I'm inclined to call you Mr. Homer.
Sorry, I wasn't swanking, but I'm just saying that everybody makes mistakes. Maybe I make more.
I will call you Mr. Fitzgerald. Mr. Ratwell, thank you very much indeed to you for your oral submissions, to everybody who's been involved in the preparation of the written submissions. The board will take time to consider what advice they will humbly tender to Her Majesty.